Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip is directed or intended for you brokers and managing brokers out there. Today we're going to cover the art of writing the 10-day letter. So what is the 10-day letter? Basically, if a buyer and a seller go under contract and then fail to close, the holder of the earnest money may disperse the funds upon written agreement by the parties separate from the document that directed them to hold the earnest money. Now that's license law. Then in the GAR and the RE forms purchase and sale agreement, one of the ways that if the parties don't agree in writing, if you don't have agreement, for example, on a termination release agreement, by the buyer and the seller agreeing as to how the holder is to disperse the earnest money, then the holder has the option of several things to do. The holder can interplead the funds, or what the holder can do is what we lovingly refer to in the industry as write the 10-day letter. And what that means is the holder has the option of doing a reasonable interpretation of the contract, giving notice to the buyer and the seller as to their intent to disperse the earnest money. Now, before actually dispersing the funds, we must give the party not getting the funds at least 10 days to object to our decision. That's why we call it the 10-day letter. So basically what happens is a broker goes through the contract, finds out why didn't it close. Did the party that terminated the contract, did they terminate within an unexpired contingency? Did they terminate default? What happened? What were the documents that were signed? What did the purchase and sale agreement say? What did the exhibits say? What did the amendments say? Am I in possession of all the amendments? So forth and so on. So there is some research that goes into it, and this process must be followed. Even, for example, let's just say a buyer and a seller went under contract and had an 8-day due diligence period. Let's say the buyer terminated within the due diligence period. Let's say the buyer terminated within day 5, but for whatever reason, the seller won't sign the agreement to release the earnest money. That's a situation where the broker must do this 10-day letter. That one's shouldn't be too difficult, but that's where the broker has to do the 10-day letter, and still has to send notice as to their intent to disperse the earnest money, wait at least the 10 days, and then disperse the earnest money. So that one would be a pretty cut and dried one. There are other ones where they are way more complicated, or there are things that have gone that have been negotiated between the buyer and a seller by amendment. And for example, if a buyer terminates under a financing contingency exhibit, what was in the loan denial letter? Did it match the terms of the financing contingency exhibit provisions as provided for in that exhibit, and so forth and so on. So there is a lot of research and interpretation that brokers do in order to write this letter. Then these brokers write this letter. We must send it out per the notices section of the contract under which the parties were binding prior to dispersing the earnest money. So brokers, the art of writing the 10-day letter. Just a few tips and tricks to make sure that everybody understands what is going on, why you have interpreted the contract in such a way that you did, and just understand what it is that they had agreed to. So just a few tips. Number 1, remember your audience. Your audience is the public buyer and the public seller. So write your letter with them in mind as the audience, not the other real estate professionals. Now, the other brokers are going to get a copy of it, and the agents will get a copy of it, but your audience per the letter is directed towards the public buyer and the seller. And your buyer and your seller, remember, may not be as familiar with real estate lingo, terminology, contracts, so forth and so on, as other real estate professionals. Number 2, just simply go in chronological order. Go through the contract starting with the purchase and sale agreement, and in your letter state or reiterate what it is that the parties had agreed to. For example, you would say, and then you use the contracts or the forms as evidence of what happened, what the situation was. So for example, you would say the buyer and the seller agreed to purchase a property located at 123 Lucky Street and went binding on these terms on December 19th, 2019. That they agreed to their due diligence period of 10 days. See paragraph 6 of purchase and sale agreement. They agreed to a conventional loan, a financing contingency with the buyer getting a conventional loan. See Exhibit A, blah, 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 blah. So you tell the story and then reference the documents that they had signed as evidence for how it is that you came about the story. So you're going to go in chronological order. Buyer and seller went binding to purchase this home on December 19th, 2019. The contingencies that were agreed upon between the parties were a due diligence period of 10 days. See paragraph blah, blah, blah for purchase and sale agreement. A financing contingency with a conventional loan for 21 days, thereby ending on January whatever date 2020. See Exhibit A. Contingent upon the sale or lease of the buyer's home prior to January 15th, 2020. See Exhibit B, sale or lease contingency exhibit, da 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 da. So you tell the story starting with the purchase and sale and referencing the exhibits that they had signed as evidence as to how you know what had happened, what they agreed to. Then you would say the parties agreed to remove whatever contingency by amendment fully executed on December 23rd, 2019. See amendment number 1. So you start in chronological order per the documents that they had agreed to, and you go on in explaining what the story is. And then you would state, based on the agreements between the buyer and the seller, the buyer has terminated by default, therefore the seller will disperse the earnest money in the amount of X amount of dollars to the seller 10 days after date of this notice. Any objections must be in writing and sent to so forth and so on. So go in chronological order. The third thing is watch your vocabulary and your lingo. And again, keep in mind your audience is the public buyer and the seller. So for example, let's say that you are referencing a sale or lease contingency exhibit. Don't just say per GAR form F601. Who knows what that is? My goodness, some agents don't know these forms by the form number. So you would say the buyer and the seller agreed that this purchase and sale agreement was contingent upon or was subject to the buyer selling their current home on or before whatever date. And then again, as I just mentioned in parentheses, see GAR form F601 Exhibit B. So watch your lingo and your vocabulary. The next item is just state the facts. Just go by the contract, the exhibits and the amendments, and what has been agreed to between the buyer and the seller. Don't put in anything else, but just go by the facts as to what the parties had signed. And then lastly is keep this, again, following with just go with the facts. Keep this truly factual. Keep your opinion and your emotion out of it. Because when it comes time to have to interpret a contract and disperse the earnest money, you have now put on your neutral hat that I am the holder of the earnest money. I have been entrusted with these trust funds to do the right thing per the agreements between the buyer and the seller regarding dispersing these funds. I have been entrusted with this escrow deposit, and I have to be neutral in this situation and do the right thing. There's no opinion, there's no emotion, you just go by the facts and interpret the contract and what they had decided. And so what I mean by that is watch your language in your letter. Don't use words like unfortunately, or, you know, for example, you don't want to say, so therefore, unfortunately, I am dispersing the money to such and such. Well, it's only unfortunate for one of the parties. It's fortunate for the other party. So keep those words that have anything to do with opinion or emotion completely out of the 10-day letter. I think that's it. Thank you guys so much for watching. Hope this contract tip helped out you brokers in writing. Again, there is not a science to it. It is definitely an art in writing a 10-day letter. Thank you guys for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.